Welcome to week 4 of Hazardous Waste and Public Law. This week we're going to be taking a look at the EPA enforcement of RCRA and then an interesting side issue of brownfields. And this should come as no surprise to you, but RCRA is actually enforced. And one of the primary mechanisms of enforcement is the permitting system. The slide after this one will go into a manifest in more detail, but as you can imagine, permits are required for everybody. Generators, transporters, TSDFs, everybody needs a permit and everybody needs to do the manifesting paperwork. One interesting aspect of permitting is the exportation of hazardous waste. And this would fall under the international environmental law regime. The Basel Convention is mentioned here because that relates to the transboundary movement of hazardous waste. The convention requires appropriate disposal in the importing country and, most importantly, re-importation of waste material that was not properly managed in the importing country. A key item to consider with international environmental laws is you have to determine if each of the involved countries is a signatory to the law or the international convention. Sometimes countries will sign the convention and abide by it. Others will sign it and take a long time implementing it, and others may not sign it but still go ahead and implement it. So each international environmental law needs to be evaluated individually. The American system of government and law is based upon checks and balances. With respect to the EPA and the permitting, you have to realize that the EPA is not a rogue agency. The federal court will have jurisdiction to review EPA regulations and EPA's either denial or issuance of permits. So if a citizen or a company believes they have been treated unjustly, there is judicial review, which could lead to remedies and force the EPA to correct their actions. This type of judicial review is often referred to as formal adjudication, and this is an administrative law term which goes into separation between making rules and having judicial cases. The EPA is not necessarily having its hands tied and not able to act or react in a timely manner. Section 7003 of RCRA provides the government with a means of responding to existing contamination problems. The relief provided by Section 7003 is equitable and frequently takes the form of an injunction. And this section may be applied to inactive sites as well as active sites. As mentioned in the previous slide on permitting, here's a picture of a hazardous waste manifest. There are 3 main parts, one for the generator, one for the transporter, and the last for the TSDF. Each of these parts would be filled out in its entirety and signed before going to the next person on the list. And the person at the bottom of the list is the TSDF, the disposal facility. The loop is not closed here, because how would the generator know that the waste has been properly disposed of? Well, the completed manifest is sent by the TSDF back to the generator to close the paperwork loop. The generator has a certain amount of time in order to receive the completed waste manifest with all the signatures. Otherwise, the generator needs to get on the phone and try to track down the waste and what happened to the waste. RCRA gives the federal government a very wide range of enforcement provisions to ensure compliance with the hazardous waste management provisions of the Act. The EPA is authorized to assess civil penalties for past or current violations, issue compliance orders, revoke permits, or seek temporary or permanent injunctive relief. RCRA also contains criminal provisions for knowing violations of the Act. Criminal liability may apply to both corporations and their responsible officials. RCRA actually contains an interesting component entitled citizen suits. Up to now, we've only discussed generators, transporters, TSDFs, the EPA, and maybe the state regulatory agency that's acting on the EPA's behalf. What if you, the citizen, have determined that something is just not being done right, the law is not being followed? Well, RCRA permits an individual to sue in federal court to enforce the waste disposal requirements. The interesting part is the prevailing parties, if you win, can obtain injunctive relief, civil penalty awards, litigation costs, expert witness fees, and reasonable attorney's fees. However, this would be barred if EPA or a delegated state has already commenced and is diligently pursuing an enforcement action. An individual, a private citizen, can also sue the EPA for coercive fines imposed to induce compliance and punitive fines imposed to punish past violations. The Supreme Court in the past has held that RCRA precludes recovery of past cleanup costs and must be a continuing danger at the time of the suit. Now, before you go out and intend to sue somebody immediately for a hazardous waste violation, please be aware that the enabling statute of RCRA often defines a number of parameters that must be complied with before you can sue. And this would cover topics such as ripeness, standing, and mootness. So there are administrative law hoops that would have to be complied with, and also constitutional law requirements that would be reviewed. So citizen suits do exist with RCRA, but proceed with caution. I want to conclude this week's presentations with a mention of brownfields, or more specifically, Brownfields Economic Recovery Program. The EPA has announced a series of programs to encourage and empower states, localities, and other agents of economic redevelopment to prevent, assess, clean up, and reuse contaminated community property. Brownfields are abandoned, idle, or underused industrial and commercial facilities that the EPA hopes to remediate and reuse through the Brownfields Action Agenda, announced in January of 1995. You'll cover this in a lot more detail in the weekly readings.